you for returning. I hope you're enjoying the event thus far. Before us now is a panel on the United Nations Declarations of the Rights of Indigenous Peoples, Indigenous Engagement, and the Future of the Academy. The panel description goes something like this, that the UN Declaration on the Rights of Indigenous Peoples was developed to address harms such as dispossession of land and resources, discrimination, forced assimilation, and other grave human rights abuses. That's right out of the document, if you wish to go look. In doing this, the Declaration provides a framework for reconciliation that protects Indigenous rights, such as the right to practice culture, language, and self-determination. In many parts of the world, Indigenous rights and entitlements are not being honored, and the struggles of Indigenous peoples and communities are still a reality. This panel will explore the rights of Indigenous peoples and how academic endeavor and activism may support our journey toward justice. I'm really pleased to be introducing the moderator for this panel. Malcolm King is Scientific Director of SCPOR, Saskatchewan Centre for Patient-Oriented Research at the University of Saskatchewan. Professor King is a citizen of the Mississaugas of the Credit First Nation and a health researcher at the University of Saskatchewan. Professor King served as Scientific Director of the CIHR Institute of Aboriginal Peoples Health from 2009 to 2016. And is currently the Scientific Director of the Saskatchewan Centre for Patient-Oriented Research. His research is aimed at improving wellness and achieving health equity for First Nations, Métis, and Inuit through strength-based approaches that respect self-determination and privilege Indigenous ways of knowing. Honored with a National Aboriginal Achievement Award in 1999, he was elected a Fellow of the Canadian Academy of Health Sciences in 2016 and a Fellow of DRSC in 2021. Welcome, Malcolm, and take it away.
Thank you very much, Chimagwech, Frank. And it's a pleasure to be here with you and with these three illustrious panelists who will speak in turn. I just want to start off, as others have, with a couple of comments about the passing of Murray Sinclair. He, of course, led our Truth and Reconciliation Commission and its calls to action. And his words have been widely quoted, but I want to bring them to this gathering because I think they're very important. In presenting the report to the Government of Canada, he talked about, we have described for you a mountain, and we've shown you the way to the top, but we call on you to do the climbing. And further, he went on to say, reconciliation is not an Indigenous problem, it is a Canadian one. And it is one in which all Canadians are implicated. And I think going even further than that, if I can, United Nations Declaration on the Rights of Indigenous Peoples is not a settler concern. It's not an Indigenous concern. It concerns everyone in the world. And I think our three panelists today will bring out those aspects. So without further ado, I've asked the panelists if they would kindly introduce themselves, because I think they will do much better justice to their introductions than I could do. And so we're going to start off, first of all, with Professor Tom Kalma, who comes from Australia. Professor Kalma.
Thank you, Malcolm. And I guess my slides will come up, or do I have to kick them up? But look, let me start by saying thank you for both the introduction and also the welcome to Canada, and on behalf of my colleagues who are here, we'd like to recognise you all. I'm Kungarakan on my mother's side, Iwaju on my father's side, and my grandmother is Wulwanga, my father's mother was. And I'd like to recognise the local owners here, and also pay respects to elders past and present, but also to recognise their youth, as we should for all youth, who are going to be our future leaders, the custodians of our stories, our cultures, our histories, and our languages, as we've just heard. So it is critically important that we do hear and listen to our youth, and also show them the right path to take on the roles that they'll be faced with into the future. Australia is a bit like Canada. It's very, very large in landmass, and the map on the left indicates the number of different tribal groups in Australia, and there were between 250 and 360 that can estimate at the time of colonisation, and they were the languages as well. But when the map on the right indicates where, and those little red dots, I hope you can see them up there, indicates where the Aboriginal populations are. And as you can see, they're in remote Australia, very arid lands, and very small populations. So they're not very, very significant at all in number terms. And so that's why there's a bit of a challenge. So today I wanted to just spend a little bit of time talking about the Declaration on the Rights of Indigenous Peoples, but also come and look at it, how it's going to inform the way we go about our business in the academies. What's worth recognising is that it took 20 years to develop the Declaration, and so those 20 years led up to when it was actually passed in 2007, and then you add on another 17 years since that happened. So we're nearly 40 years down the track from when we first started talking about the Declaration to now where we're at, and that's a real challenge, particularly when you look at the countries that at the time 4 countries opposed it: Australia, New Zealand, Canada, and the US. A number abstained, and the rest of the world voted for it. So even though our 4 countries, the Kansas countries, opposed the Declaration at the time, they're still bound by it now through the Universal Periodic Report, and now that it's passed as a Human Rights Declaration. So if we have a look at an extract, just and I'll leave this, and there'll be a number of slides with a bit of info on them. Some of them will have links down there, so you can go and explore that a bit later. But I guess the key thing is that these are the extracts in the sort of preamble, or what they call annex to the Declaration, and it really does talk about respecting and promoting the rights of Indigenous peoples, respect our cultures, our traditional knowledges, and our practices, but also to respect our treaties, and seeing the treaties where they exist around the world as an opportunity to create better relations with the state or the government of the day. Do you hear that, New Zealand? You're in the process of that being unwound, or attempting to be unwound. So treaties, whilst they exist, may be under some threat around the world. And of course, there is an obligation on all the states, which means countries, to really put into effect what's in the Declaration. So I think they're really important, looking at them. And the first, 3 and 4 articles of the 45 relate to self-determination and what we as Indigenous peoples can expect, and how we can express ourselves through the process of self-determination, but also the obligations of governments to respect that self-determination, which is, I guess, a really important tenet for all of us. And that goes down to all of our respecting our cultures, our languages, our traditional knowledges, and how we're governed, how we choose to be governed, how we educate. So all of these come under the right to self-determination, and also I think recognising that when we look at the Declaration, contrary to what people say, there's special rights for Indigenous peoples, they are the same rights as all peoples of the world are able to enjoy, with one exception, and that is that we have communal rights, and that, you know, they're not individual rights. We have individual rights, but also communal rights. And so, you know, land is communally owned, language is communally owned, culture is community owned. And that's the big distinction between what the Declaration articulates and what everybody else enjoys as a human right, including ourselves. I guess when we come down to you know, Article 31, which is the important one that looks at cultural heritage and you know, traditional knowledges and traditional cultural expression, and it goes through and talks about in that, and this is what's really, I think, has a big impact on our academies and how we actually interpret Article 31 and put that into effect, and how do we make the work that we do in the academies recognise that, and get the membership of the academies to recognise what we can expect and what we should expect has been articulated through the Declaration. And also at the bottom there, you'll see that it states must take responsibilities to put these into effect and enable us to enjoy our rights as Indigenous peoples there. So that's well articulated. The other important one with the Declaration is that it talks about the 45 articles in there, talk about different aspects, but we can't see them all in isolation. They're not in silos. They're interrelated, and, you know, it's what in you know, common terms we refer to as determinants, be they cultural determinants, which is something that Indigenous peoples enjoy more than others, or just social determinants. And it's how do we interrelate all of the activities that we do. And I think that's the big challenge that we've got within the academies, is making sure that we don't silo. And, you know, we've got, I think, a bit of a challenge in Australia in that our Academy of Science really does look at natural sciences, and yet we have other academies that look at social sciences, humanities, so they're all a bit discrete. And so how do we bring them together, and how do we make sure that you know, that they work together? And you know, a few of us are members of a number of academies, and so we you know, we see this in action, and how each of the different academies relate to activities. So these are the various articles in there that was I think worth looking at. And then for those that want some more information, the Australian Human Rights Commission conducted some consultations back in 2013 and produced this Declaration Dialogue series, and the link's down the bottom there. So you can look at these documents, and they just picked out some of the key ones, you know, how to put it into effect. Well, governments haven't quite learnt that yet. Again, the big emphasis on self-determination, you know, the right to participate, you know, which is a fundamental right that we are able to have, and so on that. So that's worth having a look at if you need to understand a little bit more in sort of layperson's terms, and they explore what each of the articles of the Declaration look like, or the key ones anyhow on those. Now, that was about the Declaration and what we need to consider, but there are some other global movements that are going on, and hopefully this one is on Indigenous groundwater declaration, which is very important for us for our cultural rights, our cultural knowledge, our traditional knowledges. And if you've got any really difficult questions, Brad Mogridge over there is the man that led this whole movement, and so Brad can be drawn into, you can ask him questions, and he might even want to come up and give a little spiel about it here. But it's about recognising groundwater, which is pretty big, because it's one of the big global associations is recognising traditional knowledge, which is a monster step forward. And I guess the other one that's just happened, and that was last year, this year through WIPO, we've now had the Treaty on Intellectual Property, Genetic Resources and Associated Traditional Knowledges. The first time that we've had an articulated, other than the Declaration, another UN body that's recognising traditional knowledges. And so, again, the link's down there if you want to see a bit more, but it's referred back to the two articles, 2 and 3, in the Declaration and how they relate to each other. So that's worth looking at, and from an academy's perspective, also exploring this, because we're all bound by it globally. All of our states are now bound by it, and it's worth looking at. So what are we doing in Australia? Yes, we've endorsed it. We didn't at first, but in 2009, the government then endorsed it, but then there was a change of government. And that's one of our big failings in society, is a change of government, change of direction, change of support, or withdrawal of support for Indigenous initiatives. And that was why we tried to have the referendum last year to embed in our constitution a voice for Aboriginal and Torres Strait Islander people, which in turn would recognise Aboriginal and Torres Strait Islander people, because we're not recognised in the Australian Constitution. We're the only democratic country that doesn't recognise its First Peoples. So, something we're not to be proud of, although there's still a really strong movement in Australia of people opposing anything Indigenous. And, one of the big ones now is that in Australia we do the recognition of country wherever we are, or we get a welcome to country by a traditional owner. And both major airlines will announce when they land whose country you're landing on. Whether it be Ngunnawal or Ngambri or any of the tribal groups in the major cities. But people are opposed to that. They're opposed to indigenising everything and recognising us. And in Australia, we've got, proven relationship for 65,000 plus years pre-colonisation. So it's a big one for us. But anyhow, that's the status. So that's my 10 minutes. Thank you.
So I'd now like to introduce Kara Ladner of University of Manitoba, but she will introduce herself and give a Canadian perspective on this. Dr. Ladner.
It's a really good day to be here and to talk. It's an honor to do so. Although, as I said to Frank when I was asked, in my mind still shouldn't be me that's standing up here. But I'm up here, and so here we go. Okay, I'll just maybe begin with, I want to just introduce myself as I should. My grandfather is from Niganit, or was from Niganit. Descendant of Treaty 6, not Treaty 4, although we come from a Treaty 4 community. It was only by government policy that we become Treaty 4, and I always want to recognize that, because it's those ancestors that worked so hard to get us where we were. And there's a lot of differences between our two treaties and how we think about those. So for those that don't know, I come from Saskatchewan, Cypress Hills, Okimau-Otse, where we think that all the thunder and all the world really begins. So in my mind, I come from the center of the universe. And it's a great place to come from. With language was really strong there when I was a kid. And it was always an honor to be there and to be with my grandfather and my grandmother who helped raise me. And then I grew up in Calgary, in Blackfoot country, in Nitsitapwa, and I must also give some recognition to that. I want to pay some respect to the elders that came before me as well. And why I think I need to pay that respect is, as we always do and always should, I'm hoping that I'm pressing the right button, but nothing seems to be working. There we go. So what I wanted to talk about was the kitchen tables that this comes from. Yesterday, I was on the plane when I heard of Murray's passing. Murray's granddaughter is my nephew's, was his best friend growing up. I saw Murray lots in social settings when I first arrived in Manitoba. And he became family, as did his kids. And so I think paying respect to those people that walked before us. There's always been this generation, and a generation before that, and a generation before that, that were all about our sovereignties and all about how do we deal with those newcomers. And those are the people that I think should have been speaking. It doesn't start with UNDRIP in this territory. It actually starts with treaty. That's why I say I come from Treaty 6. That treaty is only the treaty that we signed with the Crown. We had treaties that went before that. Treaties that began with the other nations, whether they be people or non-people. Those treaties weren't being honored. And so in the 1980s, as Trudeau Sr. opened up the Constitution, a lot of people came together to work towards getting constitutional recognition here. And having worked for 13 years in Australia on this, I am reminded about the task that was before these people. People like Murray's husband, Sagesh, Murray, others. We owe them, I owe them a lot. Those rights became really not rights. They're about responsibilities. They're about our laws. When we think about existing Aboriginal treaty rights, those are really about trying to find a way to get recognition of our own law, our own traditions, our ways of being. It didn't work. We're still fighting. We're still in the courts every day. And so after constitutional recognition was achieved, that journey continued. And we're still fighting with obscurative logics that the courts pose on an everyday basis through their lens of interpreting our rights. And I want to just make note, and I really did a slideshow for those that are from away, so that if you're interested in law, I should have said I'm a political scientist that works in law, plays in law, will always play in law, but I also play in digital sovereignty, so we'll get to that at the end. But the courts, through their interpretation of Aboriginal treaty rights, have really tried to put things in boxes and really tried to deny. And so we went back to kitchen tables, and some of those same people went back to kitchen tables. And when I was asked by Frank if I would do this, I said, what about Sagesh? I know Marie's coming, so what about Sagesh coming? To me, standing him up is who we should stand up, and other elders that have worked on these journeys. And I really needed to pay respect to that because we lost Murray. We're going to lose people at some point. We need to stand them up, recognize for what they've done. So that journey continued, and that journey continued into the UN. And then when we got the UN Declaration, that journey continued at home. So 2016, the Government of Canada finally endorses without qualification. But we know everything is qualified. And so the journey continued to get organizations like universities, to get governments, to get courts to start to deal with the UN Declaration. And Canada has a UN Declaration, and UNDRIPA. BC, where we're sitting, has recognized the declaration in an act. And we also sit with UBC today, which has also posed a strategic plan around a recognition of UNDRIP. But despite the fact that we've got this recognized, we're still working on how to walk it through. According to the Canada's Act, it was only supposed to provide a framework for implementing the Act. All the work has to be done yet. And that it's going to take measured moments over time to actually get this walking forward. And it's only about federal law, not provincial law, not anything else, not businesses, not how anything operates. So we went through with this action plan, and the action plan was simply the federal plan as to how they are about to implement this. And the action plan is a rather thick document that includes both the action plan as well as a document called What They Heard. And in reading through this and in working with several communities, I'm always reminded of what they heard. It kind of sounded at times like they were wearing, what were they called, the tin ears that we've heard the BC court having worn in Dalgamuk and hearing Dalgamuk go forward in court. They weren't really listening. They're talking with a good voice, but not really listening. But at the same time, there's measures that are being taken. There's movement that is being made. But if you take a look at their action plan, much of what they're saying they're going to do, they've already done, and they've called it reconciliation, or they've called it their response to the TRC, or they've called it a response to murdered and missing Indigenous women and the inquiry there. So there's a lot to do in order to force and to work and to carry the legacy of those people that stood up from those kitchen tables before. And those kitchen tables continue. And so those kitchen tables continue because we have people working through UNDRIP in court. And it's interesting to look back, even before UNDRIP was there, when it was still in a formative process, we have the Canadian court referencing this working document in Mitchell, which is about Mohawks at Akwesasne and the ability to move from one side of the territory to the other side of the territory that's divided by an international border. And in Mitchell, the chief who becomes Chief Justice says, this UNDRIP really doesn't matter. It's not going to be part of the positive law. Means really nothing. But if it meant nothing, why do they actually have to put it in the court case? Why do they have to put it in the decision? And it's all about creating that precedent and telling other courts, don't pay attention. And we have other courts that are kind of walking that way. So we have 2 cases in BC that are saying, well, this is just really, the BC law is about, we have some work to do. Let's work it together. Let's figure out what this means. But it's really not part of the positive law. But the court case in Quebec, Montour, it's actually White and Montour. I read it yesterday on the plane. After hearing about Murray, I needed something to do, so I started reading law, as every geek does, right? Well, Montour is a case, also a Mohawk case, coming out of Kahnawake. And it's a case that is really fascinating because it says that it's not only part of the positive law, UNDRIP, but that if you use UNDRIP to interpret Section 35, you can toss out all of the shit law that was given to us and create a new framework of interpreting Section 35. And this case says that if we interpret Section 35 using UNDRIP, we can start with Indigenous legal traditions. So the question isn't this permafrost, do you still have this right? And I wanted to talk about these interpretations because Australian law, New Zealand law, how the hell do you get permafrost rights or frozen in time in Australia? But that's the pieces that our courts change back and forth. And if they can change and transfer back and forth this idea of frozen in time, that rights are really that which existed when the colonizer first found you, discovered, that maybe we can actually use these and support some of the law that's going through now, these cases, not only being those activists within courts, but those activists as historians at work, the anthropologists at work, and the training that we're giving, and trying to use courts in different ways. Still not a fan of courts, but I think about how do we interpret law? How do we reconcile? And that's what my work has really been about, is that reconciliation process. And I think that we have to, as scholars, really support that rethinking when we're training young people up to become these future justices, because we're stuck with this. We have 2 Supreme Court cases that both bring in UNDRIP, but we're still stuck with things like the Vanderpeet decision. But now, you know, this Montour case will be in the Supreme Court, hopefully within the next year, and hopefully we'll see how the Supreme Court begins to deal with it, because they're bringing in UNDRIP even when UNDRIP isn't part of the proceedings, like in the Gwich'in case. So what do we do at the university? I think we have to imagine and reimagine and support that journey ahead. I always think I'm still a junior scholar. Yeah, right. But I look at the elders around and they're leaving us in the academy. So maybe I'll be that mid-career. I'll join Frank in that mid-career. And knowing that it's us that have to stand up now. And that's really what we have to do. So I imagine that journey ahead. We have to really think about those shoulders that we stand on, because that's the vision that has been brought forward. And that's a vision that I walk with. So we can talk about the action plan that Canada has developed, about education and training. We can force and try and bring these up at our institutions and say, you know, it's Canadian law. You get all your research funding. Let's do this. I think that this gives us a foundation upon which to work. But I get to this idea of UNDRIP as a forward-looking process of reconciliation. I think that when we think about this, we have to think about reconciliation not as it's been given to us by the courts or even by the TRC, but we have to think about these transformative moments, like a treaty or 82 Constitution or UNDRIP. And we have to continue to make these transformative moments. Those transformative moments that got us to this place and the disciplines that we're in, but also creating those transformative moments going forward. So I think we have to start to re-theorize reconciliation. And we have a number of people in the room that are doing this, and I think we have to support that re-theorization, but to bring it and to link it and to always make sure that it focuses on community and that transformation both of the academy, of the settler societies that we're in, that vote 95%, that 95% of the population that we have to worry about when voting. But we also have to support communities. So co-development, consultation, engagement, big words in the action plan. I worked with a community that asked if I could help them stand up against the action plan, because the action plan really gives so much empowerment towards this engagement process. That's great, right? We all want to see governments and industry and everyone talking with our communities and getting us involved in the decision making, because that's our land. Those are our That's what we are supposed to be doing. But the problem is they're working with Indian Act band councils. They're working with organizations that may not always include and often don't include women's voices. So I work with a community where women have stepped outside that band council and have for the last 40 years and are trying to put themselves as the voice of the land and as the voice of what should be there back into these engagement processes. So we have to really think about how do we decolonize and support engagement, and who are we engaging with? Traditional governments, traditional owners, or are we going to work with band councils? And we really do have to think about this. And sometimes it's the same thing. Sometimes we have communities that no longer have those traditional governments, but I think we have to really complicate and think about what we're doing. The other thing is to always go back to treaty. It's not just about we're all treaty people, but what does that actually mean? And really bringing those treaty and that sovereignty back up through UNDRIP. And one of the things that I've been working on is UNDRIP supporting communities through the development of a crowdsourced archive. And my students all wanted me to talk about this and only this, so I have to at least give it some due. We're working on this idea of a crowdsourcing of law and politics through UNDRIP and developing this idea of an international archive, digital archive, that most of us can't read these law cases. I struggle sometimes even reading the law cases, and I've been doing it for 30 years. I'm a junior scholar, right? But that putting it in words and putting it in ways that the community can understand so that they become tools for all of us. So it's not just you're seeing some cool case law coming across the screen or some cool legislation coming across the screen, that there's some way of actually sharing it and using it and really working towards that ethic of decolonization or a transformative decolonization that those elders have spoken about. So, aye.
Thank you very much, Dr. Ladner. And our final speaker before the discussion period is Leonie Pihama from Toroa and University of Waikato.
Tēnā koutou. Tuatai mihi tēnei ki te hau kāinga, te iwi Musqueam, Squamish, Tsleil-Waututh, nei rā te mihi, o te maunga titohia, ki a koutou i tēnei ata. Tēnā koutou. Huri no te whare tēnā tātou katoa. Ko wai tēnei tuaki, ko taranaki, ko kareo i ngā maunga, ko Waitara, ko Waikato, ngā awa, ko te tau rehua, ko whaingaro ngā moana, ko te ati awa, ko taranaki, ko Waikato, ngā iwi, ko ngā te rāhere, ko ngā te mahanga, ko ngā mahanga tairi, ngā hapu. Tēnā koutou. I just opened the sharing with a pepeha, what we call a pepeha, which is a cultural introduction of where I am from, to give you a sense of the lands and the ancestral connections that I, amongst my relations who are in this room, bring into this space and acknowledge from our mountains and our rivers and our lands, all of those as we meet here on the unceded territories of the Musqueam, Squamish and Tsleil-Waututh nations. It's a deep honour for all of the delegation of Aotearoa to be here, and as with all gathering of Indigenous people, whether it be scholars or researchers, this is something that we've been doing for many generations and was definitely something that was a part of the undertaking of our respective relations through the drafting and the finalising of UNDRIP. And so I want to acknowledge the work of all of those of our relations, past and present, that have undertaken that work in the time. UNDRIP has been well spoken about, and I'm not a lawyer, and I don't have a lot of legal knowledge around that, so I'm going to leave that with what we've already had shared. And I just want to open this discussion with some views from some of our people who are a part of UNDRIP that come from a Mātiki Mai Māori Constitutional Transformation report that was led by the late Dr. Moana Jackson, who many of you in this room know and are aware of in his role with UNDRIP and with Indigenous rights and Indigenous transformation. One was from Whaia Iri Hapiti Ramsden, and she talked about the declaration as a statement of the minimum rights that must be acknowledged in terms of Indigenous people, and that it was part of our wider move for self-determination, recognition of self-determination. And she stated, as an Indigenous woman, I see it as the first ever international statement about the minimum human rights standards that apply to Indigenous people, including Indigenous women and children. From both points of view, the Declaration will enable us to claim back this right of self-determination and give our people international reassurance that tino rangatiratanga, which is our term for self-determination, has a political as well as a cultural meaning. Matua Archie Taiaroa, who was also instrumental in the work around UNDRIP from Aotearoa, reminded us that the Declaration is one of many processes that we've worked upon as Māori for the recognition of our self-determination and sovereignty as guaranteed within our treaty Te Tiriti o Waitangi. He wrote, I'm reminded of the times when our old people travelled to London and even to what was called then the League of Nations in Geneva to put pressure on the Crown to honour the treaty. Well, we're back here now, but in a different circumstance, and this time we're drafting something, this declaration, which is unique because it involves so many Indigenous peoples. It's also unique because it seems to have so much in common with Te Tiriti. It seems that at last the work of all of those people, our ancestors, who travelled to Europe, might be bearing fruit. Furthermore, within the constitutional transformation document, Mātiki Mai, the Working Party aligned their views in regard to UNDRIP with that of John Mohawk, who expressed the efforts by hundreds of Indigenous people to draft the UN Declaration is another attempt to express in human rights law the basic tenets of being Indigenous, a love for and authority for the land, a resolve to enhance and protect the right to be the people of the land, the power to have sovereignty and to be self-determination, and the ancestral obligation to find a good way of relating with others. Because of our history, it also means helping us recover from centuries of dispossession by stating to the world who we are and what we are entitled to, by declaring the human rights, the humanity that colonisation has for too long denied us. Another document of significance for our people, for Māori, is the 1993 Mātātua Declaration on Cultural and Intellectual Property Rights, which alongside a range of declarations stated that all forms of discrimination and exploitation of Indigenous peoples, Indigenous knowledge and Indigenous cultural and intellectual property rights must cease. Within the Mātātua Declaration, there are a number of recommendations for ourselves as Indigenous people, including the call for us to define for ourselves our own intellectual and cultural property, given that existing mechanisms consistently fail Indigenous people. 2, that we should prioritise the establishment of Indigenous education, research and training centres to promote knowledge of customary environmental and cultural practices. And 3, that as Indigenous people we should look to establish an international Indigenous information centres and networks. Māori involvement with mechanisms such as UNDRIP and the Mātātua Declaration are laid by the foundations of our ancestors in the form of Te Whakaputunga, the Declaration of Independence of October 28, 1835, and Te Tiriti o Waitangi, first signed February 6, 1840. Both documents declared and affirmed our tino rangatiratanga, our sovereignty, our self-determination, and our fundamental rights as Indigenous people. The relationship between these documents is articulated in Te Pūapua, which was a draft report focusing on the implementation of UNDRIP, which this current coalition government has now moved to the side. The authors noted, at the heart, the Declaration, Te Tiriti o Waitangi, and He Whakaputunga mirror one another in expressing Māori authority to govern themselves and determine their own destinies. to participate in Crown governance, law and policy, and to have their rights protected. The former, the Declaration, is a contemporary expression of globally agreed Indigenous peoples' rights, and the latter, the Treaty and the Declaration of Independence, are compacts between leaders of peoples at the formation of a nation comprised of these peoples. They are fundamentally New Zealand's constitutional foundation. Whereunder it provides a framework and assertions as to our rights, we continue in Aotearoa to live with colonial rule that denies those rights. And with a current coalition government that is actively reversing any and all progressive moves that have been made in regards to Te Tiriti o Waitangi. Aotearoa, like many nations, is ruled by a conservatism at this time of the like we haven't seen for the past 40 years. Aotearoa is currently deeply entrenched in a form of political Trumpism that is doing significant harm to our people. The current coalition government has moved quickly to dismantle basic systems and processes that our people have fought for 40 years that have been developed to intervene in the deeply embedded colonising racist systems that prop up the oppression of our people across all sectors and which show and are highlighted within all indices. So I want now just to turn with that basis to the Academy. Within the Academy, we have struggled for some time to decolonise and indigenise systems built on stolen land and on the systematic denial and suppression of our language, culture and knowledges. We've challenged consistently the epistemic violence perpetrated upon our people, the denial and denigration of our knowledge, the erasure of our language and culture across all colonial institutions in our country. All Western universities in Aotearoa have been built on the dispossession of our people and have benefited throughout history from the ongoing dispossession. It is not in the interests of universities in our country to decolonise or indigenise. That has become very clear. The only time we see any attempts within those power structures to make any form of change is when it's enabled by some form of financial or economic benefit to them. Most systems changes within the Academy in Aotearoa are performative and short-lived. Changes in funding, structural arrangements in all academies are inevitably lead to the demise of Māori developments, of Māori people and Māori scholars. In particular, when we look at the Royal Society, a recent proposal to reduce the number of directors on the board has brought extreme concern for Māori. The reduction of the numbers on the board will also reduce our rights as Māori to being just one other interest group within a range of interest groups. Indigenous people are not just another interest group. We are tangata whenua, we are the people of the land, we have treaty relationships with the Crown, and that means we have treaty relationships with all agencies on our lands. What we see consistently is our rights being positioned as subservient, often in restructuring to what is considered expedient. We're yet to see institutions such as Western universities and agencies, including our own Royal Society, to take a clear public position on the epistemic violence against Indigenous people and our ways of being. For meaningful relationships to occur for Indigenous scholars and Royal Societies, there must be a greater and visible and enduring support for Indigenous people and knowledges throughout the Academy. I want to turn now to the second part of this panel, which is our role as Indigenous scholars. There can be no Indigenous academic endeavour that is not activism. Indigenous scholarship without a commitment to activism, without a commitment to the well-being of our people, without a commitment to the vision of self-determination, is in and of itself an act of supporting the conservation of the existing order. Through our work, through our scholarship, through our research, we as Indigenous scholars must make a contribution to change, to freedom, to liberation, to transformation, to sovereignty and self-determination. It is through our work that we become what Graham Smith has called He Ringa Raupa. He Ringa Raupa is a person with calloused hands. They are the ultimate worker. Their work for our people is shown in the practice of what they do. To be an Indigenous scholar is to be a worker for our people. It is to be a ringaropa. And Indigenous peoples within this room will have your own terms and ancestral sayings around this type of person. All Indigenous academic and research endeavours grounded within our cultural ways that are driven by our people's aspirations and visioned in a way to bring transformative changes for our people across our life experiences must be activist endeavours. Within Kaupapa Māori, a Māori philosophy for change and transformation, we are committed to the disruption, the dismantling, and the transformation of current systems that continue to subjugate our people. All successful transformations for Māori in our country have been created by, defined by, and led by Māori. We have established our own cultural systems and institutions that have at the central focus the revitalisation and regeneration of our language, our culture, and our knowledge forms. We have done that irrespective of the ongoing systematic denial of successive colonial governments. As Indigenous scholars, we have no option but to challenge all and any versions of colonisation that reproduce the domination of our people. To not do so is to surrender, and we will not surrender, nor will we relinquish our rights to continue to fight for the rights of our people, both within our own lands and globally. In the words of our own ancestor, Rewe Maniapoto, ka whawhai tonu mātou, ake, ake, ake. We will, as Indigenous people, fight on forever. I want to also acknowledge that today, November the 5th, is the anniversary of the pāhua in Pariaka, the invasion and occupation on our tribal lands of the militia on November the 5th, 1881. It is a significant day as we move forward. One of the sayings that we carry from Te Whiti o Rongomai is "Nau te pāhua tuatahi, nāku te pāhua whakamutunga." You may have done the first plunder, but the final solution remains with us. In saying that, I want to revert back to the Mātātua Declaration and one of the recommendations of the Mātātua Declaration, which is to establish an international Indigenous network of scholars. Part of bringing this, of coming together, in my view, as a partnership across Indigenous nations, is to actually begin to form an Indigenous to Indigenous conversation that needs to happen outside of the Royal Society, but must be supported and resourced by our Royal Societies in order for us as Indigenous people to create the Indigenous network that we need to support each other in our own self-determination. Nō reira, kia koutou katoa, tēnā koutou, tēnā koutou, tēnā koutou katoa.
Thank you, Dr. Pihama, and our other two. So we have now time for discussion, and I have a Slido here, which I will try to use. Maybe, Frank, you need to help me or somebody. But we could start off, if there are questions. There's 2 microphones, and would invite anyone in the audience to go to one of those microphones and ask questions of our panel. I see Dr. McCormick coming up. I recognize my colleague.
Thanks, Malcolm. Actually, it's a question for Leonie. You'd mentioned this, UNDRIP's clause or statement around self-determination. Years ago, I was in a conference in Aotearoa. It was in Rotorua, and it was the 4 countries that hadn't voted against it, were represented there. And it was a Maori lawyer that said, the government lawyers have a problem with one little word consisting of 2 letters, and that is the right of self-determination versus the right to. And they didn't like of, so they wanted to, because to is aspirational and it might happen sometime in the future. They didn't like the word of because it had implications, just like free, prior, informed consent. I just wonder if you could comment a little bit about that tiny distinction.
Kia ora. I can't really comment on the distinction in legal terms, but what we do know is that the four countries, and we should not be surprised who they are, held out for some time. And actually, Aotearoa signing the declaration in the end was only as a result of the Māori Party going into a coalition government of the time as a minority party, and them having that as one of the requirements for their joining the National Party of the time to become government. Or we may not have signed for a lot longer. I think it was 2010 when we finally signed. But also, our government they don't like the S word, they don't like the sovereignty word, and they don't like the self-determination word. And so a recent ruling by the Waitangi Tribunal in one of the Northland claims very clearly states the tribunal's view is that Māori never ceded sovereignty. And that has made a whole lot of issues for the Crown in and of itself. UNDRIP, in terms of where we are now, Te Pūpua was drafted under the last Labour government. We now have a right-wing coalition government, and Te Pūpua will not come back on the table while they are in government. And that was a more recent development and Cowan will know more about this probably later, that was an implementation plan that's come, 15 years or 14 years after signing. So,
Anyone else? So we have a Slido question from Brad, and it's basically, the age of being engaged is over, we're tired. How do we move to marriage or true reconciliation? And when is the UN DRIP honeymoon? I imagine it's, I'm not sure exactly what that means, but how do we move to reconciliation? And maybe we could ask all of the panelists to, Tom or Kira, if you want to start.
Thank you, Brad. I guess there's, on how we're looking at reconciliation and what it means. From an Australian perspective, it's how the general population reconciles with the First Nations peoples, and not the other way around as many people think it is. And they also get a little bit confused because I'm co-chair of Reconciliation Australia, have been for the past 14 or so years, and our CEO and our CEOs have been Indigenous, and they think it's an Indigenous movement when it's in fact it's a mainstream movement recognising who we are. I think until the time that the government's actually put in place legislation to recognise all elements of the declaration, because the declaration is a non-binding document. It's just a human rights, treaty document, and it's how that's implemented in the countries through through legislation. And once it's in legislation, then we'll get others to recognise the rights of Indigenous peoples. But from our perspective in Australia, they're struggling to even look at formal mechanisms for truth and reconciliation or truth-telling movements. There was a change of government, 10 days ago or so in Queensland, and they've now abolished the truth-telling commission that had just been established under the previous government. At a national level, they're not progressing truth-telling at this stage because the opposition is opposed to it. And so, I often say that the government of the day's got to grow some of those things that make them a little bit more powerful and want to take risks and have respect for us as Indigenous peoples. They can on the one hand, but on the other hand, if they're not putting it into legislation, then, it really relies on goodwill. And it's until that happens, then I think we'll always have opposition from some people, as I mentioned earlier about the acknowledgement of country and the welcome to country that ceremonies that take place. There's opposition, and social media has got a lot to take responsibility for in this space, because one individual can get hundreds and hundreds of blogs out, which really distort the impression, understanding of the community on either support or opposition.
Thank you. Dr. Latner?
Just a quick comment. Sorry that I wasn't quick before. I guess my apologies to the panelists, because that wasn't what I had intended to do. So the slides, yes, are going to come out. I had done them really for the purpose of handing out. In terms of moving forward, I think that there's some really phenomenal thinking that has gone on about how to move to marriage. And I am mindful of Moana Jackson's work. I think that his work on that ethic of decolonization is really, I think, that vision of a marriage, of moving there for us. And I take it here, and I think about it here, and I think about what that means here. People like John Burroughs are really working out the details of that marriage, and how do you reconcile legal traditions? How do you reconcile two sovereigns within the same space? But I think that we have to just continue to engage. We have to support our communities that are doing that work, and we have to work within our communities. But I think we also have to continue to engage and to fight those battles within the universities. They're never going to change. They're just going to be colonizing spaces. But taking up space and making sure that those spaces are there for that next generation, I think is that way of educating that future, and maybe changing some of those, that 95%. One of the other things is AI. All this misinformation and disinformation. There's a number of people, a number of Indigenous scholars that are talking about reusing AI and reusing these bots to pose reconciliation within a positive frame. So rather than misinformation, to engage and to propagate days on different systems and really engaging in different ways. And there's probably more coming out of that in the next couple of weeks after a meeting of this group and a meeting of minds on that. So I will also share with the RSC on that if it goes forward, that idea, and for greater participation.
The term reconciliation is not really a term that we use in Aotearoa, because in our view we have nothing to reconcile. We have honoured the treaty, we have honoured our role and our obligations as Indigenous people to be good hosts of those that have come to our land. And I want to just really affirm Tom's comment around reconciliation is for others to do and to work on. The notion of marriage, that's a problematic notion anyway. If we look at the relationship with states and Indigenous people, it's generally an abusive relationship. So we're probably looking more at a divorce in order to have a form of power relationships that become equalised and stabilised in partnership. And I guess in Aotearoa we've never had an UNDRIP honeymoon because we've never got married to them. We don't have to live together to actually get on. So that's one thing. But the other thing is that at the fundamental base of self-determination, if we come back to the kind of engagement with our rural societies, I think Anne-Marie talked about the Pacific, the new Pacific development. What is fundamental in hearing that around that Pacific development is that the Pacific nations are self-determining. That's the difference. Pacific nations can create self-determined cultural frameworks and models for their people because they're in charge of their land, irrespective of some other influences that come in. They have fundamental control and governance and sovereignty of their lands. So in Aotearoa, that is actually what is the required commitment for changing structural impediments, is the reclamation, the return and recognition of our self-determination. And that comes, I think, first and foremost, with us as Indigenous people having the spaces to talk with each other and to be able to enact that with each other, first and foremost. And I didn't get an opportunity. Oh, the other thing around the G7 cultural heritage statement, the word Indigenous does not appear in it, to mind. It doesn't have Indigenous people in it. And so where that may be an opening in the space, we need to open it even more. And by nature of who the G7 are, we can actually recognise why that's not the case. But we are looking for more than that. And just before I finish, I just want to acknowledge Marie Batiste. We have a long-term relationship with Marie in Aotearoa and Joanne Archibald of the Musqueam Nation here, who have been very instrumental in supporting, informing Indigenous education and Māori education in Aotearoa, and I really want to acknowledge that while I have the opportunity and give our greetings from Linda and Graham and their apologies for not being here.
Thank you all. There's a question from the microphone there, if you could introduce yourself.
Tansi Mahiganisqueo Sonesipik Nitsigasan. My Cree name is Wolf Woman by the Running Water. My English name is Tara Million. I really appreciate and have been touched by all of your words. I find them very exciting and they're creating a lot of thought. One of the things that I was interested in was kind of picking up on this idea of Indigenous to Indigenous conversation outside of the academy, and that as a way of moving forward certain ideas. And then the concept of Indigenous knowledges in the plural, and of course legal pluralities. And we often talk about plurality or reconciling in terms of Indigenous and non-Indigenous, or colonizer and colonized. But I would be interested in hearing your thoughts and perspectives on how do we do that if we look at reconciling and legal plurality and knowledges in the plural amongst Indigenous peoples, because I think it's problematic to fall into romanticizing that kind of marriage and relationship, and instead important to look at the realities of how we as Indigenous people treat each other in both healthy and positive and uplifting ways, but also in very problematic and violent ways. So I would be interested in hearing your thoughts.
So that sounds like a question for any and all of you. Who wants to start?
Thank you for the question. I think that we really do have to work at the reconciliation amongst us. Our treaty relationships that ground the way in which I think about treaties is those treaties that came before. So between Nehiho and Nitsidabwa, or the Blackfoot Confederacy, and those Yellow Dogs and the Young Dog Creek, that I think is really important to have those conversations. How do we live together today, and how do we stop taking each other down? But I live in Winnipeg now, so every time I live in what used to be Roostertown, which was a Métis. Adele Perry has written on this. She's here, which was a Métis community that they went in the 1940s and 50s and just bulldozed over and built my house. I didn't know that when I moved there. So, but why I say Winnipeg and why I mention this is because we're in a community where it's the Métis homeland, but there's a lot of tension, and there's growing tension between Indigenous scholars and from all of the nations, Nihio, Métis or Michif people, others, on how do we actually live together and how do we, are we talking the same things when we're actually talking about people walking over each other's rights. And that's something that I think we really need to do, is to listen to communities and the struggles and to support those struggles. We have a number of communities in Manitoba that are saying, this isn't Métis territory, this is Anishinaabe territory, or this is Nihio territory. And how do we actually have those conversations about living together a better way? And we've forgotten to, I think, continue those conversations in good spaces. And so that's one thing that I think we do have to do and support. And how do we do that supporting community also within the academy when ourselves as scholars are probably also creating so much of those tensions as well. So, hi.
Yeah, thanks. Look, I think it's a really important question because, even when you look at our three countries, all different in the way we operate, our legislations, our constitutions are different. Australia doesn't have a treaty at all with any of our people, and the treaties vary. So it's it's complex, but I think this is what we tried to achieve through the declaration, and that was by bringing together Indigenous peoples from across the world to look at what can be common amongst us. And it's not saying that we need to homogenise all traditional knowledges. They're all going to be discrete to the owners of that knowledge, the language owners. We talk about languages. There's so many different languages around the world and within countries, and we're respecting all of that. And I think that's the challenge for governments, and that's why it was ironic that the Kansas group all opposed the declaration when they're all different in the way their relationships with their first peoples. So there's a lot of challenges, but I think the declaration is the one document that recognises individually and collectively the rights of Indigenous peoples globally.
I have to apologize. There were lots of good questions that came through on Slido, but just in 2 or 3 minutes ago, it wasn't working for the longest time. But we do have a question from the microphone here, and maybe we'll start with that one.
Yeah, my name is Carla Jessen Williamson, and I'm aware of the fact that each of the nations that we are talking about, Canada, New Zealand, and that of Australia, run on democracy system. And here we are in Canada, and where the Indigenous peoples are extreme minority groups within these democratic systems and treated that way. And more often than not, the rights and their ways of being are not at all looked after by the democratic systems. In fact, we have a situation where each of the departments and whatnot actually practice genocidal practices. So here in Canada, at this point, there's more than $500 billion income that the Canadian federal government obtains through the use of the lands here in Canada. And I just often wondered about the financial reconciliation in that regard, to look after the needs of Indigenous peoples as being the first peoples of these various countries. So I think in many ways that the finances of each of the nations had to be really well analyzed to see what kind of mechanism can be put in place to ensure that the needs of the Indigenous peoples get to be met. And that to me is reconciliation. We have many different kinds of explanations and thought on what reconciliation is, but where it should be unquestioned is the fact that we are the first peoples of the land, and therefore we need to be looked after. Democracy as such is looking after the settlers by their millions and forego the rights of the indigenous peoples that way. Thank you.
Would anyone like to take that on?
Well, the Declaration talks about reparations and that it's a state responsibility to do that. And some jurisdictions do that. In Australia, there's been movements to recognise, and as you have over here, for people who are forcibly removed and put into boarding schools, there's been some reparations made there, and there's been a number of different activities in Australia by the various states to be able to do that. But, whether that's adequate or not, and whether that's a one-off, as many people are seeing it. And in fact, in Queensland, where it was about stolen wages, where the government actually took the wages of Aboriginal and Torres Strait Islander people, their reparation is just paying back what they took. So it's not even paying for rent on the land or use of land, etc. But in the Declaration, it was made pretty clear that that's the responsibility of the state.
Yeah, thank you. So I'm going to go to an anonymous question, and it's about the voice of youth, and I think that's an important thing. The question is, where do you feel the voice and agency of Indigenous youth fits into the future and shifting of the Academy? Leon, please.
Yeah, without doubt, within these countries, rangatahi or young people, youth have been marginalised consistently. And, it's something that we're working on really hard and fully at home in terms of, because we have a construct of what we call whānau, and whānau is multiple intergenerational knowledge and systems of being. And so we need to return, in my view, to that process of ensuring that all parts of the whānau, all intergenerational knowledge, all intergenerational voices, all intergenerational ways of being are affirmed and acknowledged within our work. I hear these terms that come through research around emerging researcher and midterm researcher and senior researcher, and, I just really don't know where they come from. I really don't. They're a very institutional way of perceiving ourselves within our knowledge forms and our roles and obligations as Indigenous people in terms of our language, culture and knowledge. We have a whole range of other notions that we talk about. But, if you come into this room as a fluent Māori speaker and knowledgeable in your knowledges and you're a young person, why does that make you an emerging or a new scholar when you have a greater fluency than I have? So there's all these systems of that we need to interrogate around how we talk about the relationships that we have intergenerationally with each other. Okay? Within Te Ao Māori, we are all ancestors and we are all descendants, we are all grandparents and we are all grandchildren simultaneously. So we have a role to ensure that all of our children, all of our young people are engaged, all of our diverse communities are engaged, LGBTQI, takatapu communities, differently abled communities, all of our communities, all of the parts of our whānau, because we are whānau, we are relations, and that should be at the critical centre of how we do things. So ensuring and trying to disrupt the way in which we are siloed, not only in disciplinary ways, but in experience ways, and knowledge ways, and age ways, and sexual, all of those ways is something that we have to disrupt and really work to dismantle and operate in ways that are supportive of an intergenerational way of being across our people, in my view.
One of the...
Sorry. No, you go. I didn't see you there. I'm always talking, so you go.
Okay.
I I was just going to say one of the cool things that is happening out of my lab, and this didn't come out of me, is to engage youth through a hackathon. So we've been having problems with building technology for a crowdsourcing archive that allows us to restore for community or to have individuals restore, whether it be with our Walking with Our Sisters archive, telling different stories and claiming stories of to commemorate the women and the sisters that have gone missing or have been murdered, or to talk about UNDRIP, or so we have multiple platforms. But bringing in youth and getting them interested through different technologies, whether to build a video game around UNDRIP, which is being discussed, or to build a platform, or to learn about beading so that they could bead QR codes and put them throughout campus to tell different stories. There's ways to engage youth where they are using technology. And I think that that's really, I see it more and more of a way to go, because that's the language that they know. That's a language that they're comfortable with. They're more comfortable behind the screen than many are without a screen in front of them. So use that to our advantage of a way to engage them, and they should always be there. So, Bill.
Yeah, look, I can only talk from an Australian perspective, and from our academy, you know, we've got to build our whole cohort. In 2022, I was appointed as a fellow. I was the first Indigenous fellow. I'm still the only Indigenous fellow of the academy. We've done, I think, a good start to getting in early career researchers involved in the process, and but we've also got to reach out to engage our youth. May not be as fellows or members of the academy, but to be able to hear what we're talking about, because we do some great work in you know, groundbreaking research into you know, into the sciences, but that stays often within the academy or at a very high level. It's how do we then engage with our youth? One of our partner institutions is Questacon in Canberra, which is our national centre, and that's engaging a lot of youth. The transition onto the academy, or the relationship with the academy, is a little loose, but you know, that's one of the ways. But it's providing information and engaging and welcoming our youth to be party to what we do within the academies, I think, is so important.
Yeah, thank you. I know lunch is coming up soon, but maybe we have time for one more question over here.
I don't have a question. I have information to offer to our collective here today. I'm Penina Harding, and I am focused on developing my specialization in the field of Indigenous environmental planning. I am Secwepemc. I am from Eskedem, and one of the challenges that we have within the Secwepemc, our territory, is that not each of our community fires has the same capacity for administration, the same capacity for access to our territory and our responsibilities as guardians and stewards of our territory. And so what I've started looking for back in 2018 in my master's thesis was, how do I manage this information? Can I create something that will increase equity for each of our community fires in our territory from an environmental planning perspective? How can we manage the information? And what I came across was the land administration domain model. It is essentially, this is a very short summary because we don't have much time. It's a computer network system that tracks the rights, the roles, and the restrictions of Indigenous land. So if you are from a treaty nation, how many years have your people been gathering and preserving and storing traditional knowledge, your knowledge systems in your treaty territory? Now, in the Eskedimkuluk, we actually voted down the treaty negotiation process and we redeclared our title and rights. So our perspective on this work is going to be different from those who have a historic treaty or have negotiated a modern treaty. But that doesn't mean that we can't work together to preserve Indigenous knowledge systems and make sure that those community fires who don't have the same access to technology, internet infrastructure, it doesn't mean we can't work together. And so I encourage everyone here to look into the land administration domain model. Because if we want to develop an international collective system for Indigenous knowledge governance, we need to create our own land administration domain model. And to do that, we need to have people who know how to use blockchain technology. Because the idea is that we use the blockchain technology to create this computer network system. And that system is governed by the Indigenous community, the nation. It could be a treaty association representing a group of community fires. But we are the ones who say who has access to that information. And if a government person wants to come and have access to our knowledge, they need to fill in an application and tell us exactly why they want access to our knowledge, what they're going to use it for, how often they're going to use that information, and then report back to us. Because we don't need to wait for government to build this system. It's our job as the Indigenous knowledge keepers and knowledge holders, as the future ancestors, to create these systems, to lift each other up. And that's the kind of work that I would like to be a part of and that I'm trying to be a part of. And this is something that I think we all need to be considering. Like, what would that look like for your people, for your community fire? Because each community fire has a different need and has different resources. Some nations are stronger. They have more in the way of finances. But other nations are strong in culture and language and ceremony. How do we work together to share the work? Because it's not just one community fire's job, it's all of our responsibility. And I thank you very much.
Thank you for your contribution. So we're going to have to close this off, and I'd like I'll give a big round of applause to our three panelists.